Welcome back to Criminal Law class. In today's class, I will explore the law on self-defense and the three-part test and how special rules apply to householders facing intruders or burglars. When can self-defense be used? Self-defense can be used as a defense to a wide range of criminal offences, particularly those involving violence. This includes assault, battery, Section 47 ABH, Section 20 wounding, Section 18 GBH, attempted murder, and murder. If successful, self-defense is a complete defense, meaning the defendant is acquitted. The legal test for self-defense is primarily set out in Section 76 of the Criminal Justice and Immigration Act 2008, which restates and clarifies and codifies much of the common law position, that is, those decided past criminal cases. The test when using force is lawful involves asking three key questions. The first question to consider is whether the defendant's use of force was for a legitimate purpose. According to Section 76(2), the force must have been used for one of the following legitimate purposes. In short, these are self-defense, defense of another, defense of property, prevention of a crime, and assisting in a lawful arrest. If the force was used for a purpose of retaliation, revenge, or because the person was provoked, then the defense of self-defense will generally not apply. The second question to consider is whether the use of force was necessary in the circumstances as the defendant believed them to be to achieve one of those legitimate purposes. This is a subjective test based on necessity. That is, the defendant's belief in the specific danger they faced and the imminence of that danger and or perceived danger. Under Section 76(3) and 4, the court must consider whether the defendant honestly and genuinely believed that the use of force was necessary in the circumstances. There are two important principles when considering necessity to use force. These are: 1. There is no duty to retreat. Section 76(6)(a) confirms that the court may consider whether the defendant could have retreated, but there is no legal obligation to do so, and also as per the case of R versus Bird. And the second principle is preemptive strikes are allowed. A person does not have to wait to be attacked if they reasonably believe an attack is imminent, as per the case of R versus Beckford. Importantly, Section 76(4) says even if the belief was mistaken and unreasonable, the defendant will still be able to rely on self-defense as long as their belief was genuinely and honestly held. So, for example, imagine a man walking down the street and someone bumps into him. Believing he is being attacked, the man pushes the other person away. If the man's belief was genuinely and honestly held, even if mistaken and unreasonable, it can still form the basis of lawful self-defense, as per the case of R versus Williams. There is an important limitation in the law on mistaken belief in using self-defense, if claimed by the defendant. Section 76(5) in short says that a person cannot rely on a mistaken belief to use self-defense if it was caused by voluntary intoxication. So, for example, a voluntary drunk person mistakenly thinking someone is attacking them and lashes out cannot rely on self-defense as a defense. This principle was established in the case of R versus O'Grady, 1987. The third and final question to consider is whether the amount of force used or the degree of force used by the defendant was reasonable in the circumstances. This is assessed objectively under Section 76(6) and 7. Even if the defendant believed they needed to use force, it must still be proportionate to the threat they face, as per Section 76(6). There are two important principles at play when it comes to the amount of force used by a defendant. The first is the greater the danger the defendant faces, the more force a defendant can lawfully use. And the second principle is Section 76(7) recognises that a defendant who is acting in self-defense and under pressure may not be able to weigh to a nicety the exact measure of any necessary action. And there is evidence the defendant only has done what the defendant honestly and instinctively thought is strong evidence in their favour. In relation to the third question for householder cases, Section 76(5)(a) is also important to consider. There are special rules on the amount of force a householder can use compared to non-householder cases. Where the defendant is a householder facing an intruder or a burglar, the law may allow for a greater amount of force used. In short, the defendant may be able to rely on a disproportionate amount of force, but not grossly disproportionate amount of force against an intruder. Importantly, the term householder refers to a person in their home, as per Section 76(8). Force used by a defendant while in or partly in a building or part of a building that is dwelling. For example, imagine a householder hits a burglar once with a bat. This may be disproportionate, but still may be considered reasonable and therefore lawful use of force. However, if the householder repeatedly beats an unconscious burglar and intruder after the threat has passed, this may be grossly disproportionate and the defence of self-defence would likely fail. Each case is fact-specific. This point is highlighted by the real and high-profile case, an example of R versus Martin back in 2003, which led to the possibility of greater amount of force used by householders with the insertion of Section. The basic facts were Martin shot and killed a burglar in his home. He was charged with murder. He claimed the amount of force used was reasonable. The jury found him guilty of murder, presumably rejecting his self-defense argument, as they may have considered it unreasonable amount of force, that is, excessive. When he appealed, he claimed he suffered from paranoid personality disorder that caused him to perceive greater danger to his physical safety than the average person in the same situation. The Court of Appeal held that psychiatric evidence on Martin's condition was not an exceptional case and therefore the evidence was not admissible. However, Martin's conviction for murder was substituted for a conviction of manslaughter on the basis of diminished responsibility. So just to summarise, point 1, remember the three-part test as set out in relation to when a person can use force lawfully. Point 2, the use of force must be for a legitimate purpose, as per Section 76(2). Point 3, the necessity of force is judged subjectively based on what the defendant honestly and genuinely believed, even if mistaken and unreasonable, as per Section 76(3) and 4. Point 4, a mistaken belief based on voluntary intoxication will not afford a defence of self-defence, as per Section 76(5). Point 5, the amount of force used must be objectively reasonable, whether in a householder or non-householder case, as per Section 76. Point 6, in a non-householder case, the defendant can use proportionate amount of force, which is considered reasonable in the circumstances, but not disproportionate amount of force, as per Section 76(6). Point 7, in a householder case, the defendant may use disproportionate amount of force, which is considered reasonable in the circumstances, but not grossly disproportionate force, as per Section 76(6). Thank you for watching the series on defences so far. I hope you found them clear and useful. Feel free to comment and follow and subscribe for more criminal law classes in the future. Thank you.